Awesome, thank you. So my name is Linda. Oh, I'm just going to mute myself, really. Actually, no, I shouldn't do that. We have panelists. Oh, my mic has been disabled. Technical issues, which is very on par with me. I just think we have to drag them.
Yeah, let's just do it all the way.
I think we fixed it. We did not fix it. Well, that is fantastic. Well, everyone, my name is Lyndall Goodemond. I am a symposium editor for the Vermont Law Review. I want to thank everyone for coming today, and I want to thank Charlotte, my symposium partner. It's been an honor and a privilege putting on these events with her so far. I want to just have a few quick shout outs. I would like to thank Professor Varadi, who is our moderator today, and also helping us with tech issues. And I would like to give a very warm welcome and many thanks to our fantastic panelists today. I have done so much research on these individuals, and I am really looking forward to a diverse and really engaging conversation. So I do have some slides. We could transfer to those. I am going to be giving a brief presentation about our topic today, which is AI and its use in producing child sex abuse materials. I do want to give a quick little bit of a trigger warning in the fact that towards the end, I do mention a recent case involving child pornography. Outside of that, I have kept it as generic as possible to be mindful of the audience. So this is our AI symposium lecture. I'm sure all of you understand to a degree what artificial intelligence is. Even if we try to avoid it, AI is prevalent in all areas of our, all areas of our lives. It is a simulation of human intelligence. It's tools and algorithms and output that learn how to mimic human cognitive behaviors. And the end goal for all AI programs, for the most part, is to react as a human would in decision making. So main form of generative AI is if you go on ChatGPT, which I'm sure almost everyone in this crowd is familiar with as law students. If I put in a text prompt asking it to provide an outline or asking it to provide me with a picture, it will generate that for me. And for every individual who is using it to generate pictures of cats and emails and outlines, there sadly is an individual who is using it to create child pornography or child sex abuse materials. Now, in my research on this topic, I have found 4 major concerns. First is civil and social concerns. When we're approaching delicate subjects like this, it's incredibly important to realize that the legal aspect of it is only one small part of that. We have legislative concerns on a federal and state level, constitutional concerns, which I'll touch very briefly on. Our fantastic Professor Vesland is going to be giving an overview of First Amendment concerns in relation to this topic. And finally, criminal concerns. Now, for social and civil concerns, I just want to touch briefly on how these child sex abuse materials are created. An individual will either go on a private algorithm or on something like ChatGPT. We do have mainstream. Do we have another tech issue?
It's a small one, just let me
You got it.
Thank you.
Thank you. And also thank you to our fantastic IT department for helping us every week with this. But the way that these materials are created is an individual will put a text prompt into a program detailing the type of child they would like to see, age, location, and the sexual act. And these algorithms will produce either photos or images, or most recently, videos. 2023, we discovered there was a huge increase of the production of these materials. They are getting more and more severe. They are getting more realistic. We are struggling to decipher what is captured by a human. Typically, child pornography and child sex abuse materials are captured with a human behind a camera and a real child that is dealing with the harm and trauma of being put through that. But now we're struggling to figure out if it's that or if it's been created by a computer. Horrifically, videos with audio are now being produced as well. These items are being found on what they call the clear web. Those are websites that you and I encounter every single day. They are hiding in the nooks and crannies of advertisements and videos. And with the rise of social media and mom influencers, we have a real issue with child celebrities, child stars, and known victims being used to create these materials. That's another huge issue with generative AI is all AI needs a database to go off of. These programs use hundreds of thousands of images of children across a wide range of information that they've been given. So sometimes if it's not used a known victim to the perpetrator or a child influencer, it is actually the creation of thousands of children making one AI-generated child with one AI-generated voice. Now, there are legislation concerns because you're probably wondering, that's horrific, what are we trying to do about it? Well, the federal government does have a few solutions. We have a few proposed acts. I found this one, I think it has a lot of potential, specifically because not only does it do reactive work, but proactive work of trying to target arrests while collecting data on how these things are created in the first place. One of the most important things when dealing with child pornography and child sex abuse materials is figuring out how they're created, who's creating them, and how we can stop it before an arrest even needs to be made. Now, states have been seriously popping off in AI legislation over the last 2 years. There's been almost a 200% increase on legislation, either proposed or enacted. However, this is a pretty unprecedented issue, so I decided to include a map of all the states that regulate sexual deepfakes. AOC, Michelle Obama, Taylor Swift are individuals who have been subjected to AI deepfakes. A couple years ago, Emma Watson was caught reading the Mein Kampf. That was a deepfake. These things are hyper-realistic and meant to target certain people. However, these deepfakes and generative AI are now being used to create child pornography. A lot of AI legislation is based on serving to cover up a loophole or to fill in a gray area that our current legislation does not cover. Certain states that have laws in the books right now are Idaho, North Carolina has a few proposed, Washington, D.C., Massachusetts, and there are legislatures in Vermont who are looking to get laws like on the book to protect our rural communities. First Amendment concerns, I am going to just briefly put this up here. Professor Vesland is so phenomenal in this and will be going more in depth, but there are a lot of First Amendment concerns regarding this just because AI cannot just be shut down. If you don't like it, I'm sorry, it is here to stay. We are going to be dealing with it for a very long time. And there are challenges to freedom of expression with certain images. But the main part of this is discussing the criminal concerns. Typically, as I've mentioned, with traditional child pornography, there's a human, a camera, and a child. So it's produced in a way that we know how to track, and it is distributed, sold, and traded in a way that we can understand. We already have systems put in place to catch this happening in real time. However, with AI, that is not the case. There are situations of, is it the chicken or the egg, which came first? Should we go after companies that are building these algorithms? Should we go after the people that are creating it in these text prompts? Should we go after people who aren't checking how their algorithms are being used? Where does it begin and where does it end? And it's the same with possession, because typically we can track people down who are using this, but sometimes people slip into the ether, especially when they're hiding under new technology that we just don't know how to track yet. And that leads me to the biggest part of all this that I cannot drive home enough is a concept of harm. I've had some really phenomenal conversations about this, of the fact that there are real children that are being subjected to AI-generated child sex abuse materials. There's also an argument that no real harm came, especially if it's 100% generative, because it's thousands of children and thousands of voices to create a fake child. But there is a really real harm to using these tools and using this to create these images. I just want to drive this home by giving an example of a recent arrest that happened last year. North Dakota, a child psychiatrist was arrested for having child pornography on his personal laptop. From the alleged allegations made against him, there were 3 kinds of child pornography that were found on his laptop. The first one being generative AI, using thousands of children to create images. The second, using his own patients in child pornography. And finally, he discovered photos of him as a child in which he used to create generative AI of classmates he had when he himself was a child. A woman was approached by the FBI and thought she was being scammed until she was shown a black and white photo of her 15-year-old body used in a sexual act. That man created real harm. It does not matter that it started with a generative AI of a potentially fake child. Real children that deserve safety are being used to create these images, and it led him to using more sophisticated technology that he had access to that led to real harm of not only his patients, but grown adults being used as retroactive child pornography. Now, there are responses and initiatives. First is coming to symposiums like this. I truly believe the first step to finding solutions to unprecedented issues is having open dialogues from diverse backgrounds. Education is one of the most powerful tools we have when it comes to protecting our most vulnerable population, which is children. We have government and law enforcement actions already on the books on a state level, and we're steadily working towards federal legislation, and I do hope we have it before it is too late. Typically, with these topics, we are faced with not knowing how to rapidly evolve when systems like AI are evolving behind our own comprehension of the topic. We have legislative efforts as well that work with local law enforcement and, most importantly, nonprofits that educate children and their families, educate people who use social media to make profit, which is something we'll also be discussing on October 10th for our labor law panel. And finally, although I often believe talk is cheap, even though I'm giving a lecture today, tech companies have started making commitments to protecting vulnerable populations, including children and the elderly. Very first thing that we can do as a society is acknowledging the issue and also acknowledging a Band-Aid cannot be slapped over it. It takes the work of every individual in this United States and also on a global scale to tackle this at home and within our own governments. So I want to thank all of you for coming and for listening to this. I understand it is an unpleasant conversation to have, but as young professionals and as people in law school, especially people who go to a school based on advocacy, it is essential that even if we do not go into the criminal field, that we understand this will impact every child in our lives, whether it happens to them or not, because we simply right now do not know, and there is power in educating ourselves and power in taking steps forward to protect our communities. Thank you.
Thank you, Lyndall. That was outstanding and thought-provoking. Hi, good afternoon, everybody. I hope this symposium finds you well. No, seriously, thank you for making the time to join us, and thanks to those of you who are here online. My name is Ben Verratti. I'm an associate professor of law here at the Vermont Law and Graduate School, and truly honored to be moderating this panel of the Fall 2024 Vermont Law Review Symposium, Safeguarding Tomorrow. As Ms. Gudemond mentioned in her introduction, these are intersecting areas of law and technology and culture that are experiencing radical evolution as we are collectively seeking to best navigate the relationships between our interconnected society and the potential of emerging technologies to fundamentally alter the ways that we communicate and relate to each other. The human experience will be profoundly different in coming generations, and the choices that we make now are helping to shape to what degree that vision will preserve and protect our values, preserve and protect the interests of our most vulnerable populations, and we need to be cognizant of the potential both for unprecedented new opportunities, but also opportunities for unprecedented harm. This is in many ways a test of who we as a species want to be in the future. And these early conversations that we are having are very much going to help define our path. Our format today is uncomplicated. We're going to hear from each speaker, followed by a conversational session, including questions that were previously submitted, fielded by members of the Law Review, and also the audience, if you're here in the room. You know, I was told this event is going to be fairly sparsely attended, so we're going to keep the camera on you. And now I'm looking out at a sea of faces. So thank you all so much for being here. If there are questions in the room, I think we can get a mic circulating at that point. If you are participating in the Teams channel, do feel free to raise your hand there, and I will do my best to monitor that on the laptop. We are going to try to get to as many folks as we can, and really mostly I just want to dive right in. I am personally so excited to hear from this amazing panel. We're really fortunate to be joined by some incredible thinkers in this space who collectively are standing at the forefront of considering artificial intelligence in a child protection context, both in theory and in practice. Today, we're joined by attorney Harshita Ganesh, Professor Pamela Veseland, Dr. Britt Paris, and attorney Natasha Amlani, who are each bringing deep experience and fresh insight. We're so very appreciative of their time and their perspectives. So with that, I think we can begin by introducing everybody to our first speaker. Harshita Ganesh is a recent graduate from Georgetown University Law Center, where as a member of the American Criminal Law Review, she's published works on the intersections of law and technology, also looked at women's rights post-Dobbs. Her professional experience includes work on prosecution of sex crimes, litigation analysis, and extensive scientific research in biochemical engineering that I will not pretend to understand. She's also had leadership roles in a number of influential programs that were providing both direct support and advocacy for female-identified populations. Thank you so much for joining us, Attorney Ganesh.
Thank you.
This is a moment of awkwardness where I had been expecting to introduce people one at a time. I'm realizing now everybody else is expecting me to do intros and then roll into it. Let's do that. We are also joined today by Professor Pamela Vesseland, who is familiar to most of us in this room and many of us online. Professor Vesseland is a resident expert on the First Amendment. For those students in our community, be aware that that course she will be teaching this spring. Do consider that. She is also extraordinarily well-versed in civil procedure, administrative, and animal law, and has conducted extensive inquiry into constitutional law with a particular focus on the rights and needs of non-human animals and the people who interact with them. She's published on a number of speech issues, including explorations of the government's ability and some of the limits in regulating obscenity in the context of animal law. She holds an LLM with honors from the University of Arkansas, and perhaps most importantly, is a 2008 graduate of Vermont Law School. Thank you so much, Professor Vesseland, for being here today. Also on our panel, Dr. Britt Paris is a professor of library and information science at Rutgers New Brunswick School of Communication and Information, an expert in critical informatics. Dr. Paris focuses her research on the political economy of information infrastructure as it relates to evidentiary standards and political action. Her work has extensively explored questions of political economy and culture relative to emerging information and data sciences, publications testing assumptions underlying our current information technology landscape, and raising issues relative to generative technologies and evidentiary challenges therein. She's a Master's in Media Studies from the New School in New York, a PhD in Information Studies from UCLA, and a book coming out from the University of California Press titled Radical Infrastructures, Imagining and Organizing a People's Internet. Dr. Paris, thank you. Welcome.
Thanks for having me. Happy to be here.
We're also joined today by attorney Natasha Amlani, a lawyer in private practice who advises clients on platform regulation, digital safety, human rights, and user data privacy, and importantly, I think their interrelationships. She focuses particularly on risk avoidance relative to online safety, relative to the complex and shifting worlds of online safety, disclosure, and privacy law as it stands, and I presume as it is developing. That work includes counseling clients on government surveillance and privacy for communication providers, and counseling on child safety reporting law at all levels of government, locally, nationally, and internationally. She also has a recent publication in Just Security in conjunction with the UCLA Promise Institute for Human Rights titled AI Exploitation and Child Sexual Abuse, the Need for Safety by Design. Thank you so much for being here.
Happy to be here.
So with that, I think what makes sense is to get started, let y'all expand on those introductions to the degree you'd like, and share a little bit about your work and your thoughts in the field, and then we'll transition into conversational space. Attorney Harshita Ganesh.
Hi, really happy to be here. So, like you previously introduced, I recently graduated law school in May, so I'm a baby attorney. I just took the bar in July, so pending licensure. And while I was at Georgetown, I was on American Criminal Law Review, and I published my first paper, which was on exploring the very uncomfortable area of deepfake AI and child pornography. And when I wrote this paper and it came published, it was in November, I believe, or a little shy of November 2022, which was right before or on the cusp of when ChatGPT became common use amongst peers. That's when it exploded in law school. People were like, have you seen this? You can put in a case name and it'll give you a case brief. No, it won't. It'll give you a hallucination. But yes, that's when it became really big. And when I was writing this paper, I wanted to take a step back and put myself in a very uncomfortable position. And when I say, if anybody has read this paper, I will tell you, I had to shower and scrub my skin a lot while writing this paper because it was very uncomfortable, and it's a very icky subject. So in my paper, I explore and take, a step back to look at, where do we originate from a moral standpoint when it comes to child pornography? And let's separate ourselves from the law for a second and think about, where are the issues that we have with it? And then it was trying to explore, what are potential solutions that we can have while we may not like them? What are ways we can avoid this abuse? And, when we talk about this more, I'm sure in, the panel, I do want to preface it by saying, I think child pornography is abhorrent. I think it's disgusting. And I think it's one thing we all as human beings can agree on is an evil that should never exist. But aside from that paper, while I was in law school, I was also the co-director for the Women Project, which is a nonprofit that pushes for reproductive rights in Rhode Island. And I was also a part of the Taunton Diversity Network in Massachusetts, and I was a sexual assault and domestic violence survivor program coordinator. And I spent some time in the DA's office working in felony trials, where I got to work in sex trafficking and prosecuting sex trafficking. Currently, I am at a wonderful firm named CMBG3, and I do corporate defense work, which is not, related to this topic, but this is a big passion of mine. And I'm hoping soon, once I get my license, I'll be able to do some pro bono work representing domestic violence victims in court through a friend's nonprofit in Rhode Island. But that's a little introduction about me. So.
There we go. In terms of the work that you've been doing so far, where do we originate from a moral standpoint? I think that's a question worth exploring a little bit.
Yes. So, I think when we look at child pornography and we dig deep and see what's the main issue we have with it, is I don't think we necessarily as a society have an issue with the sexualization of children. And I say this because if you look at a lot of our pop culture, we encourage some very uncomfortable and disturbing behavior amongst young adults. Think of Toddlers in Tiara. Remember that nightmare? Toddlers in Tiara. We have Lolita. We have several mainstream TV shows or films that have inherently sexualized children. So I don't think we have the problem with that. What I really do believe as a society we rightfully have a problem with is the memorialization of a child's abuse and having it plastered and almost set, a visual depiction of it. I think that's truly where we have a big issue with child pornography from a moral standpoint. We are very, it upsets us as a society to have the memorialization of a child's sexual abuse or abuse in general. So that's where I think we stand, from a moral standpoint when we look at child pornography. I think that's what you were asking.
Yeah, absolutely. That's very helpful, and I think that's useful framing moving forward. Professor Veselin, I know that you have looked at this issue both specifically as to generative AI and more broadly. Welcome.
Hi, thank you very much. You guys hear me okay?
Yes.
Wonderful. I am very excited to be here and to learn from our panelists today. I want to spend a few minutes going over what the First Amendment has to say about AI-generated child pornography, and explain why it's not an esoteric or meaningless discussion. Really, there are actually some very real-world practical reasons why we need to consider the First Amendment in attempting to regulate AI-generated, AI-generated anything, but certainly child pornography. And then I'd like to finish up with some questions, because as is usually the case when you go to start researching something and start trying to think about it in a more than just surface way, you start to come up with more and more questions than you had even previously. And so I do think that this area is full of questions and inconsistencies. To begin, the First Amendment says that Congress shall make no law abridging the freedom of speech. Of course, that has been incorporated to the states, and so that means that the government may not abridge freedom of speech. When I say speech, if you haven't had First Amendment or studied this before, understand that we're not just talking about what I'm doing right now, speaking, but actually audio, video, real or virtual videos, still photographs, drawing, expressions that these are generally considered speech that are subject to free speech analysis. Now, the act of making or disseminating the speech product, if you will, is part of the speaking process. That is, you can't share a video if you don't create the video. So that can also be considered the speech that needs to be protected. However, what is not protected is the act of abusing children in the creation of child pornography. So because that's considered conduct and not speech, I want to separate that out as not what we're talking about here. The actual abuse of children is separate from this First Amendment analysis, because that is not speech, it's conduct, and it's appropriate to regulate it. So the statement that Congress shall make no law abridging the freedom of speech, of course, sounds absolute. But as you know, there is no such thing as I don't want to say there are no exceptions, but there is practically an exception to almost every rule, and there certainly one is here that the government may regulate speech. And there are basically two main categories in which it may. And the first is that if the government, if you will, has a compelling interest, a really important interest in regulating speech, and the way that it goes about regulating that speech is what they call narrowly tailored, carefully crafted to regulate that, to meet that compelling interest. That meets what, for those of you who have had con law, refers to as the strict scrutiny analysis. And therefore, the government may regulate speech in the case of a strict scrutiny, meeting strict scrutiny analysis. Secondly, the Supreme Court has over the last 100 years or so, basically come up with some categories of speech that it considers to be outside the scope of the First Amendment. In other words, we say that it's not, these categories of speech are unprotected by the First Amendment free speech guarantee. And you've probably heard about some of these or heard of some of these. Obscenity is considered an unprotected category of speech. In a quick nutshell, obscenity is pornography that is so outside the scope of what our society would accept as in sexual matter, as anything at all. It's so beyond the pale in terms of what is acceptable that we would consider it patently offensive, quote unquote, and that it lacks any serious literary or artistic or political or scientific value. So obscenity is a type of speech that is not considered protected by the First Amendment, and the government may regulate it however it wishes, certainly within a legitimate basis standard. True threats, that is, the government may regulate or prohibit, punish those of us from making, from threatening others and putting them in fear for their reasonable fear for their safety. That's not considered protected speech. There's something called incitement speech. That is the type of speech that is meant to incite or encourage, convince somebody else to, in a short period of time, commit a crime on their own. If you know that you're the kind of speech you're whipping people up into, or a person up into a reaction where they turn around and burn down the building or something like that, then that type of speech could be considered unprotected speech. The government may regulate that. Of course, you know that that defamatory speech, lying about somebody, saying something that's false and presenting it as true when it injures that person. That's something that the court has said defamation can be regulated within certain parameters. And of course, commercial speech. Labels are regulated, again, within certain parameters. These are just examples of the kinds of speech that are, either outside the scope or somewhat outside the scope of the First Amendment's protection. We can look at these categories from a couple of different angles, and I think this is where it gets kind of interesting, at least to me, and that is that what do we mean? What do these categories have in common? Is it the focus on the speaker, the intent of the speaker? So a speaker who intends to threaten somebody, to put them in fear for their safety, or put them in fear for their even perhaps not even safety, but their life. Is the intent? Is it what makes it a true threat? The speaker's intent, or is it the way that speech is perceived, the way that the listener hears it, and if they are a reasonable listener, they feel threatened by that speech, or how the intent of I should say the false or misleading commercial speech. Is it the intent of the company that's making the product that puts puts claims on their label that's untrue? Is it that we are concerned about, and we should be thinking about what their intent is? They're trying to convince consumers to buy something perhaps that's different from what they think it is, or do we look at the way that commercial speech is perceived by the person, the consumer themselves? Anyway, what's not on this list of unprotected speech is pornography. Pornography is considered protected speech within certain limits that deal with things like, when you think about movies that are rated X or rated R, or whatever, that minors can be restricted from being able to access pornography. But as a general matter, pornography is protected unless it is pornography that is obscene. And there's, in 1973, the Supreme Court finally landed on what we are still sticking with, what's known as the Miller test from a case called Miller v. California, in which the court said that speech that is obscene has to be of a sexual nature. It appeals to not just a sexual nature, but a prurient interest, something that is, as I said before, so beyond the pale, so outside the scope of what is acceptable in our society. And sometimes that societal standard is actually considered on a much smaller scale, like within a rural community versus a metropolitan community. It has to be lacking in any serious value otherwise. Anyway, if something is considered obscene, and it is pornography, of course, then it can be regulated, it's unprotected. But none of this is really dealt with the question about child pornography until 1982, when the Supreme Court, in a case called New York v. Ferber, decided to essentially create an additional category of speech that is considered outside the scope of the First Amendment's protection, and that is for child pornography, period. doesn't have to be considered quote unquote obscene. It is any pornography that, as defined by the state, using children, also again defined by the state, may be regulated by the government. In this case, it was a New York criminal statute that banned the distribution and promotion of child pornography for children under 16. And so where we are today with this, with artificial intelligence, kind of stems from this Ferber case and the basis that the court used in deciding to create child pornography as a separate, identifiable, unprotected category of speech. And that is that the court looked at it basically 5 different reasons why the court thought that child pornography stands alone as an unregulated, outside the scope of the First Amendment. And one is that, states have a compelling interest in protecting the physical and psychological welfare of its children, and that the distribution of child pornography had this not only an initial effect on children when it was created, but had this ongoing effect that the creation of child pornography, whether it's in images, still images, or video, what have you, it's going to continue to exist. And even as the children grow up, they can and are likely to be continuing to be hurt or potentially be hurt by the existence of this memorialization of pornography. The closing the distribution gap or closing the distribution network was considered to be an extremely important part of shutting down child pornography. Skipping ahead a little bit, the court said that child pornography generally has de minimis, like really very little value to begin with. And so it thought that it was appropriate to create under Ferber this separate area of unprotected speech. So where does that leave us with artificial intelligence? The most important thing that we get from Ferber is that it is child pornography as is outside the scope of the First Amendment that the government may regulate, is that it has to actually involve the use of real children. And so in a subsequent case, 20 years later, 2002, the court held in Ashcroft versus Free Speech Coalition that banning the virtual child pornography is actually overbroad and unconstitutional because there are no actual children there being harmed or who will continue to be harmed. And so we essentially are left with a situation today under First Amendment doctrine that the 2 main ways that child pornography, I guess deep fake or however you want to call it, either whether it's using actual pictures of children and superimposing other images so that it makes it look like they're engaging in certain acts, or creating from scratch, if you will, an entirely an AI generated child pornography. These are not considered part of the of unprotected speech, and therefore we're stuck with the First Amendment's restrictions and the requirement that any regulation of it qualify under strict scrutiny. Which leads me lastly then to a few questions, and that is that if obscenity in and of itself is, and this kind of goes to what Ms. Ganesh was saying, if obscenity is of itself regulable because it's unprotected, can we not all agree that child pornography is de facto per se obscene? That child pornography is obscene, whether it is generated artificially or not. And it would certainly, I think we can all pretty much agree on that idea for the most part. The problem with that is that under the progeny of Miller versus California, the obscenity cases, the court has held that the statute that restricts this type of speech or these videos, what have you, has to be very carefully drafted to meet the definition of obscenity. Secondly, I want to bring up the point that, and this again goes to something that Ms. Ganesh mentioned, I beg your pardon, that with the creation of more artificial intelligence child pornography, some scholars have suggested that this is preferable to the use of actual children and that it alleviates some of the harm in some way. And I just leave that out there as something that I'm interested in what the other panelists happen to think about that. And then I want to mention the fact that there was a case from 2011 in which California had a law struck down. It was attempting to regulate access by minors to excessively violent video games. And the case is called Brown versus Entertainment Merchants Association. It was a case in which the court held that that violence in and of itself is not an unprotected area of speech. So a very, very violent video, especially if one is engaging in violent video game, that is not that's not something that can be regulated under the Constitution unless it meets a strict scrutiny standard. And really, I would say for the most part, the reason was that there just wasn't enough science to show that there was a true connection between playing or being exposed to violent video games and suffering some sort of trauma as a result, or being induced to engage in violence as a result. And so that the very last corner of this area that I want to mention is that there is also a case that came the year before that called United States versus Stevens, which involved the banning of crush videos. These are videos that are considered a type of pornography and involve the abuse, extreme abuse of usually small animals. It is a type of pornography that is considered obscene or can be considered obscene. It is regulated under federal law, but the fact that it is regulated under federal law is creates a problem for us today when we're trying to figure out what can and cannot be regulated under the First Amendment. And that is that if you have a video of abuse of an animal and it's intended to be created as some type of pornography, then that can be considered obscene and regulated. But if it's actually just a video of extreme animal abuse and it's not put forward or received as pornography, but it's just violence, then it is protected by the First Amendment. So two videos of exactly the same thing can one is unprotected by the First Amendment, one is protected, and that leaves us where we are today, which is full with many, many questions. And with that, I'll pass it back to you, Professor Varadi.
Thank you so much. That's a really helpful background and summary of some of the current and most pressing issues, I think. Dr. Paris, we have these laws on obscenity, we have the laws of criminal law enforcement, we have the laws of evidence. Wither AI within all of that? Where do we go from here?
Wither AI indeed. So I have some slides here to remove you all from the burden of having to look at me only. Not that I haven't enjoyed looking at the previous speakers, but I have some slides here. Let's see. It's asking me to record to allow, oh my goodness. If I share my slides, it wants me to. Okay. It's saying it wants me to quit. Okay, let's see.
The more we think about technology, the harder it seems to get to actually implement it.
Yeah, right? PowerPoint Live. I just had Google Slides that I wanted to share. Is that not allowable within? I mean, I can just
It
talk,
should be, within Teams, there should be a share link, and then you can just pick a window to share.
Right, that's usually how it works. Okay. We need permission to share your screen. As you can tell, Teams isn't Rutgers' preferred mode of video conferencing. So I think I'll just talk. And unfortunately, you will have to look at me. As my introduction was so, I think very thoughtfully compiled, I'm a researcher in information studies at the corner of science and technology studies. I have a background in media and cultural studies. I do not have a background in legal studies. I do not have a law degree, so I guess I'm learning a lot here today. I do engage with a lot of, law, legal theory, and with a lot of people working in those areas. But, I'm just prefacing all of this by saying this isn't my meat and potatoes area. So I'm happy to be here today and share what I can with you all and hope that it's interesting. My interest area is how different communities of technical practice build and use data infrastructures, including those leveraged in artificial intelligence and machine learning applications, according to various values. And in the processes of building and using these data infrastructures, I'm interested in how structural power inequalities emerge and how these inequalities might be addressed to promote, better, more people-centered solutions. So I've been following, collecting, analyzing instances of deepfakes since the fall of 2017, when a colleague of mine mentioned that they had been seeing these types of videos surface in different, let's say, nefarious or dark corners of the web. This was also right before Sam Cole broke the story about the amateur use of machine learning technology to graft faces onto famous actors that were women onto already existing pornographic videos. A Reddit user posted these online, and soon after, others reported similar images that were shared with them via private groups and encrypted platforms. And this began a long-term research project that built upon previous work focusing on the politics of data construction, of evidence or of data used as evidence, and expertise within official governmental data sets. So the first output from this project was a report, sort of big report, one of the first ones about deepfakes that looked at the political and social aspects of audiovisual information objects, from video to still image to audio-only clips generated from machine learning models. So these are generally called deepfakes. And I'm also interested in, what my colleagues ahead of me in the panel have been talking about. These less expensive, less technically sophisticated cheap fakes that are produced through more conventional methods of editing or simply recontextualizing video. And I created and refined a spectrum that charts specific examples of audiovisual manipulation to illustrate how deep fakes and cheap fakes differ, obviously, in their technical sophistication, but also how people use them, right? And how they are leveraged within, sort of common practice as we engage with these images online. So this spectrum that I created has been cited by technology companies and journalists, as well as policymakers, which I'm, thrilled about, as essential to their deep fake and also cheap fake detection endeavors, even including, child pornographic child images and videos. So in work building from that original project, I argued that, this manipulated data, these manipulated images become problematic, not only because anyone with a smartphone or an internet connection and just a few images can participate in this audiovisual production and misrepresentation and, these harmful practices in imagery, but, also intervening within this problem is the political economy of technology companies, or that, includes technology companies that profit from the production, right? That profit from these data sets being used in particular ways to improve their, machine learning algorithms and their artificial intelligence data sets. They profit from this. They, get value from this, as well as the spread of these sort of amateur-driven audiovisual productions, many of which are still problematic. So, obviously, as my colleagues have been talking about, these audiovisual fakes entail these very thorny issues of understanding how mediated expression becomes evidence in ways that are explicitly political and that, disproportionately harm those who are the most vulnerable within our society, like children. And at present, even though there's been an uptick in a lot of regulation around deepfakes, there's still pretty glaring gaps in the areas of policy and governance around this amateur production of audiovisual false personation, is what I've been calling it, that lack redress for the material harm that this content often extends to these already vulnerable groups, as well as the fact that, we lack the means to scrub the internet of videos that have been found, under, existing regulation to be non-consensual, to be image-based abuse, to be child pornography. It's difficult to even find them, to track them, or to track their provenance in a lot of cases. And so, I've been following this recent uptick in deepfake law, and I'm really struck by the focus on deepfakes and not both deepfakes and cheap fakes, because, these cheap fakes are still a big problem, and they have been a big problem for a long time. And I assume, in a lot of this regulation, deepfakes is used as a catch-all for both deepfakes and cheap fakes, so that both kinds of content can be subject to the same rules and penalties. And, this will be sorted out in case law, which is not something that I, am in charge of. I'm not a legal theorist, right? But, we already know how this happens. These sort of phenomena have happened. We know from the work of Jesse Daniels and Sophia Noble, as well as legal theorists that I rely on heavily, like Danielle Citron and Marianne Franks, that the ways that these manipulated images and videos are already wielded by amateur communities, often target women, children, LGBTQIA individuals, people of color, and those questioning powerful systems. And at present, the most common technique of this artificial intelligence audio visual manipulation, the most common technique is to produce these, they're not very convincing, they're not very what do I want to say? Nobody would be fooled necessarily, but that's not the point, right? That they're realistic is sort of secondary to the fact that they exist. They, are out there for various communities to not necessarily organize around, but, create community around, and to, sort of normalize this practice, within, an individual or a community's sort of sphere of influence. So let's see, what else do I want to say here? As I was saying, there are increasingly potent state laws against producing and disseminating deepfake audio or video in many different scenarios, right? People are really focused on, and I think a lot of these state laws were sort of spurred or pushed by, the upcoming election, and there's a lot of legislation around videos that are used ahead of an election. New Jersey just introduced 3 of these laws, and I was invited to give testimony at a hearing around these bills. So New Jersey's legislation, like California's statute, requires disclosures of the use of AI-generated audio and video, or even for advertisements. And we've seen a few instances of this, but overall, people, haven't been fooled. The misleading quality of, these videos meant to intervene into elections, is fairly heavily regulated, and hasn't caused a whole lot of problems. But there's also been an uptick, I think, as Ms. Ganesh was mentioning, there's been an uptick in state laws to address the use of AI in image-based abuse, especially image-based child abuse. So New Jersey just introduced a bill that deals with non-consensual pornography and image-based abuse for, you know, people broadly, but it focused a great deal on child pornography. And as with many of the other state laws that have been introduced, much of what's stated here is around, you know, sort of penalizing people, imposing jail fines and possibly jail time if an individual is found with a certain number of images, you know, on their computer, you know, and this would now include, you know, AI generated images, right? And, you know, this statute or this sort of practice of, you know, imposing different degrees of criminal liability for a certain number of images of, you know, harmful, or a certain number of harmful images, whether they be child pornography or other types of image-based abuse, is already enshrined in case law, you know, in New Jersey, other places across the country. And, you know, New Jersey's bill around non-consensual pornography also follows other state laws in these areas. And I think, you know, every day I'm hearing of, you know, other states who are intervening in this area. So I wish I had, you know, some more positive things to say. You know, I think that these, this regulation, this sort of regulatory surge that we're seeing at present around image-based abuse and child-based, or what do I keep saying that, image-based abuse that focuses on child pornography is a positive step in the right direction, but, you know, it's coming too late and is not nearly comprehensive enough. And so I'm interested to hear from all of you who, you know, are within the legal field as to what you see as appropriate, you know, policy, whether that's, you know, within the courts, within, you know, legislation, within technology companies and otherwise, that might get at, you know, some of the thorny problems that we're talking about here today. And, you know, I always tell my students that, you know, just because we have a poison information sphere at present, it doesn't mean that we simply have to live with it. And you all know this probably as much as anybody else does. You know, socio-technical systems are built, guided, legislated by people who make decisions. And we've gotten here largely because of a deregulated information and communication sphere, sort of coupled with increased economic precarity, the lack of safety nets for, you know, people who are experiencing real problems or who have real problems. And a lot of this is offloaded onto people who are, you know, powerless to change these large-scale systems or even harmed by these large-scale systems. So, yes, I guess that's where I'll end it. Again, I don't have many answers, more questions, but thanks for having me. And I look forward to the rest of the panel.
Oh, thank you. So do I. And I think this is really a wonderful transition point in that when we speak about the communication sphere and its level of regulation and the roles of private entities within that, my understanding, Attorney Natasha Amlani, is that you're really at the forefront of that work. I'm curious to hear your thoughts on where the regulations stand and where they might go.
Yeah, happy to share that. So just for a bit more context, yes, I advise tech companies on all online safety issues, including online safety content regulation, including in connection with child safety, child sexual exploitation, as well as specifically child sexual abuse material. So things like, should a company scan for CSAM? Does it need to? If it detects it, what should it do? What are its legal obligations? And how can companies address and detect some of the broader child sexual exploitation issues like grooming and enticement, and things that propagate their own harms and can lead to further harms to children. And just before I get started, I also just really want to thank Lyndall for all of her efforts putting this together and just doing a great job of an initial stage setting presentation. I know she put a lot of hard work into this and very impressive. So starting with the US, companies do not have an obligation to scan for CSAM. And just a note on terminology, I'm using the term CSAM, child sexual abuse material, rather than the federally defined term child pornography. And this is just an industry best practice because pornography basically implies consent, and children cannot consent to their own exploitation. So companies don't have an obligation to scan for CSAM, but if they detect it, then they do have an obligation to report it. And this is really interesting with the line of generative AI CSAM and things like Professor Vesselin was saying with obscenity or other First Amendment protected content. But generally, generative AI CSAM falls into two categories, which some of the other panelists have touched on as well. So the first is deepfakes. So this is an image that depicts a real child that basically has been altered to depict sexual abuse material. And then the second is basically a synthetic image that depicts the realistic sexual abuse of a virtual, so a non-real child. So we've talked a little bit about the harms associated with deepfake images that depict also children, that depict actual children. And this includes, like Lyndall mentioned in her intro, potentially using this as a tool for sextortion, and that's the case that she mentioned. So people can basically use these altered images of a child to extract money from their victims. And this is a real harm, not just with that one case, but these types of scans are on the rise and continuing to increase. And then the second is virtual images that do not depict actual children. And I know, Professor Vesselin, you are asking about whether this alleviates the potential harm because there is no actual child that's depicted. And I think that there are a couple of harms that are still propagated by this type of content. So one, particularly since these are created using generative AI tools, the images may have been based on real abuse images. They can also resemble real children, which, as you can imagine, would be traumatic for that child and their family. And then it also sort of increases the demand in general for CSAM and for the people that are seeking out this material. So I think each set really does have its unique set of harms. And then I'll talk a little bit too about how this impacts the reporting pipeline and how this impacts the way that law enforcement can then, the tools that they have available to them to then sort of detect and prosecute CSAM-related crimes. But before I get to that, just want to talk about how companies address this. So in general, companies, though they don't have an obligation to scan for CSAM, in general, don't really want it on their service. If you're browsing for, home renovation tools or just trying to chat with your friends, you certainly don't want to come across these images. And so companies will take voluntary measures to detect this. And one of the ways that they do it is through hash matching. So what this is it's a way to take an image and basically convert it to a unique alphanumeric identifier, so like a 36 number and letter string. And companies then use that to scan for these images and then can sort of automatically detect them and then take them down. So scanning, and one of the popular tools is PhotoDNA, is a efficient way to sort of quickly identify this content, not necessarily involve human review, and detect this content and action it quickly. But with the rise of generative AI materials and the rate at which they can be created, that can't really effectively detect, or PhotoDNA hash matching can't effectively detect that content because it's not a known CSAM image. It hasn't been added to this database of these images that are known as CSAM, and so you can't really scan for it. And so what companies are doing there is, it's definitely an evolving and iterative approach, but they can use machine learning classifiers to sort of detect and see whether or not this is a likely CSAM image. And then once a company detects CSAM and reports it, so what they do is they report it to this entity called the National Center for Missing and exploited children, NCMEC. And this is a nonprofit agency that operates what's called the Cyber Tip Line, which is basically a US centralized reporting system that addresses the online exploitation of children. So they'll include things like the image, any additional information like the IP address of the user who uploaded that content, and then put all of that information in this report, send it to NCMEC. NCMEC will then review the report. They may sort of look up, okay, if I have this IP address, where is this person located? They're located in Virginia. So now I'll send the Cyber Tip Line report with any additional information to Virginia law enforcement. Or if they determine that it's somewhere outside the US, they send it to the appropriate law enforcement there. So law enforcement gets this Cyber Tip Line report with the additional information from NCMEC, and then they'll use that to investigate. They may use that to write up a search warrant request, and then maybe if this person is local, get probable cause to go search their house, maybe seize their computers, laptops, and then eventually prosecutes them. Now, with the rise of generative AI images, it sort of impacts, as you can imagine, the way that this Cyber Tip Line reporting system works. And the Stanford Internet Observatory wrote a really great paper on this. But basically, with the rise and proliferation of AI-generated CSAM and the fact that it can be created so quickly, rapidly, and at scale, it has the potential to overwhelm both NCMEC and law enforcement. Because one of the things that both NCMEC and law enforcement look at is there an imminent harm to a child here? Or is this just something, that they can prosecute or investigate later down the line? But if there's a real child that is in actual danger, they want to make sure that that's something that can be addressed and routed to law enforcement appropriately. And if someone can't even tell if it's a real child or not, that impacts the way that NCMEC and law enforcement can really act and triage. And as you can imagine, both of these organizations, or I guess law enforcement and NCMEC are already overwhelmed. And just to put in context, just the rise of AI-generated CSAM. So NCMEC received 36 million Cyber Tip Line reports in 2023, and 4,700 of them involved generative AI. And so that was 2023. And as we know, technology is changing very rapidly and quickly. And so it's something that we definitely will need to contend with. So in terms of regulation and how we're seeing this regulated and how what companies are doing to address this, there's a few different global regulations that I'm going to talk about. I think it's useful to talk about these globally because this type of content really doesn't have any borders. Many companies operate globally, and regulators look to regulations of different countries, and companies sort of try to hew their compliance measures to different regulations. So in the EU, there's this law called the Digital Services Act, which generally is thought of as a landmark law that's really changing the way that online intermediaries are providing sort of notice and transparency and taking action online. One of the requirements of the Digital Services Act is to allow users or anyone else to sort of report content that they think is illegal on a service. And so with the rise, or I guess thinking about this in terms of the rise of laws that outlaw deepfake content, these two tools work in parallel. So I guess, so in terms of who can report content, it includes groups called the Trusted Flaggers, which are organizations that are designated by each EU member state and include companies like nonprofits. We talked a little bit about how deepfakes can target specific groups, could be celebrities, politicians, more marginalized groups that are focusing on advocacy, obviously women, reporters, et cetera. And so for groups, advocacy groups that are really focused on addressing the impact of those harms and have specialized knowledge of, let's say, women reporters who were being harassed related to their reporting. They can then, and they know that there's deepfake images of them on a specific platform. They can then report that content through the required reporting mechanism that platforms have set up, and it's a way to sort of help address the content online, because a platform may not detect the content, may not be able to know in advance that that's an issue. And so it really allows people with specialized knowledge and focus on protecting these groups an efficient tool to address the proliferation of that content online. The second is a proposal. It's a proposed law, the EU, generally EU CSAM regulation, that has a few elements to it, and it's been going through substantial revision. But one of the things that it would do would create an EU center, which would be sort of like an EU-based corollary to the U.S. National Center for Missing and Exploited Children, to focus on fighting CSAM in Europe. Right now, companies just have an obligation to report to NCMEC. NCMEC would then report and share with law enforcement, including in Europe, but this would create a dual reporting obligation. Companies would need to undertake risk assessments to identify what's the risk of potential child sexual exploitation on their service and implement specific mitigation measures. Few other obligations there, but just wanted to give a sense of where regulation is going. And then lastly, just wanted to talk about Australia. The e-safety commissioner there is in charge of regulating online safety and has been a real leader in this area. And so part of the regulations there are addressing not just the proliferation of these images, but also, as we've seen in Australia and other places, requiring companies to put in place guardrails to prevent the creation of these images. And so part of the regulation there is to basically consider user safety in the design and operation of companies that have generative AI capabilities, and proactively minimize the extent to which their tools are used to produce or facilitate the unlawful or harmful material, including deepfake images and activity. So just sort of addressing the problem at another level, and requiring companies to think through how can their service be used for this potential abuse, and thinking through mitigations before that harm is even created.
Terrific. This is all hugely helpful context. And because I know we get automatically shut off at 2 o'clock, I want to make sure to make a point to thank all of our speakers right now, really, for a fascinating look at where we stand and maybe where we might go, although I think we are all a little bit tentative about that. I think, to Dr. Parris's point, events like this and moments like this are going to be mostly comprised of questions. And one of the things that's most exciting, I think, about holding these events at a law school is that many of you may be involved in finding those answers, should you choose to. In moving into a more of a conversational posture, and if folks have questions and want to come up, I am not particularly protective of the moderator questions. I think it would be great to get some dynamic conversation going. I do have a question for all of you. I'd like to start, I think, with Ms. Ganesh. You spoke a bit about our moral values and talked about some potential solutions. I'm curious to hear about those. And also, one thread we've really heard through all of these presentations is about these questions of who should be held responsible, or who should be held most responsible. One thing that I've been thinking about through a number of these presentations is about the role of content hosts and platforms. And we often offer safe harbors to the extent that these companies are engaging in protected activity or activity that appears to be innocuous. And then these questions arise, particularly in criminal context and First Amendment context, about intent. To what extent can you turn a blind eye or wait to have the issues raised, and are we comfortable with where we draw those lines. So with that framing, I'm curious to hear what folks think.
So, didn't realize we were supposed to give a much longer presentation of, our study and stuff. Otherwise, mine would have been a little longer. I kind of summarized mine very quickly, but that's a great question. When I was kind of researching and writing this paper, there were not very many, there was not legislation that was enacted in states at that time, or at least it was pending when I wrote this paper. It exploded over 2 years, where we almost had an immediate knee-jerk reaction to this prevalence and use of AI in creating CSAM. And I kind of want to talk a little bit about like AI here, to put some more context. So whenever I wrote this paper, what I had in mind as a proposed solution to an evil that exists in our world is, can we create this material without using any children as even a training point for data, right? Because transformer-based AI, that's like ChatGPT and the GPT series, what it does is it trains on a database of several images to be able to create this data, right? This output. But could we use something called GANs, generative adversarial networks, which are basically something that consists of 2 neural networks, right? It's a generator and a discriminator. And what the generator does is it creates the synthetic data. So this is what we talk about when we say synthetically created child pornography, from random noise, which basically is data, just a ton of data, which the machine finds irrelevant. While this is happening, the discriminator tries to distinguish between real and fake data. And the generator, on the other hand, aims to create increasingly realistic data to deceive that discriminator. And while that happens, the discriminator counteracts and improves its ability to differentiate from real and generated data. So I bring this up because when we talk about child pornography, we talk about it in 2 different senses when it comes to criminal law, or this is largely reductive, but since we are short on time, we have to be a little reductive here. We talk about it in the sense of possession and then the sense of distribution and creation. When we talk about possession, usually we are referring to the people who have downloaded those images and use them for sexual pleasure. And when we talk about that, I think we also need to distinguish with distribution and creation and talk about how distribution and creation is the real problem here. We need to not play whack-a-mole with the people who possess, but we need to start playing a game of catch with creation and distribution, because they are the real issues here. And it goes back into whenever we create legislation about possession, it tends to be a knee-jerk reaction saying, we don't like it at all, and if you possess it, you're probably going to abuse children. And I went into, in my paper, a study asking, well, is that necessarily true? Do people who possess child pornography, are they likely to go out in the world and abuse children? And what was very shocking to me, it was not what I thought the answer would be. I thought the answer would be yes, because when you consume child pornography, I would think that you would need more extreme material to satisfy the urge. And then when that's not enough, you'd need to go out and abuse children. Well, one, there's not enough studies out there on this, and it's an extremely nuanced study to do with a lot of variables to take into account. But the few that have done this study have found that actually, no, that is not the case. It tends to actually divert, those with pedophilic proclivities from actually going out into the world and acting on it. And it kind of diverts that energy, which also kind of causes a lot of psychiatrists and those who study this to question, is what causes those pedophilic tendencies? Is it something that somebody's born with? Is it nature versus nurture? And right now, I think the mass consensus among psychiatrists is that it is something a lot of these people are born with. So that kind of leads to another question. When we talk about the different aims and goals in criminal law, it's like we've all learned in crim law and crim procedure, it's deterrence, it's retributivism, it's institutionalization. So what are we trying to do here when we talk about the possession of child pornography? Are we punishing somebody for the thought of abusing children, or are we punishing them for actually abusing children? And this is something that I sat with very uncomfortably. And I kind of realized when we are punishing those who possess child pornography, while it's abhorrent and, again, don't like it at all, not something we like, are we punishing them for the potential of them abusing children? Is that why we're doing this? And that brings the question of, are we punishing a thought crime? That's not what we do in criminal law. If somebody goes and I kind of make this generalized comparison, which again, there's more nuance to us than that, but I make this comparison that if we go to the movies, or if a teenager goes to the movies and watches the Saw series or watches Scream or Nightmare on Elm Street or something, and these gory movies, and they're like, you know what? It'd be so cool if we went out and committed murder. Don't think anybody really does that, but let's just follow the hypothetical. Can we arrest them for having that thought? No, we can't, because they've not acted on it. They've not done anything yet. So that's where I kind of think about, well, if that is a reason for why we punish the possession of it, that may not be a solution to the major problem, which is the underlying problem is the distribution and creation of this material, which again, we have a problem with that because it is the memorialization of the abuse of a child. And children cannot consent to being a part of pornography. So inherently it is abuse. So that is where we need to start looking at the goal of legislation to protect children, especially with this digital age, and how we need to be careful that it doesn't have a chilling effect on speech in general, and how it also does not cause data privacy issues, because it is going to now start, invading the privacy of everyone who uses their technology and trying to screen. And in the wrong hands could start being used to monitor minority communities, and can be abused just as easily. So that was kind of a thought I was going along with, because if we can step back and say, look, we don't like child abuse. That is something we don't like. How can we protect children from being trafficked? And my thought was, as uncomfortable as this is, and as much as we don't like it existing, is if we use synthetic child pornography that is not based on images of other children, and if the AI machine has not been trained on thousands of images of children, would we be okay with that existing if that meant that children would not be abused to have this material? And if that could be allowed legally, would that bring a deeply underground network, which exists largely on the dark web, and it's almost impossible for investigators to play whack-a-mole, because the second you catch one, another one shows up. It's hard to even track these guys down because of VPN and privacy that's used in Tor. If we are able to surface it and bring it up, the likelihood of children being abused to produce such materials would go down, because the risk for producers of such materials would go even further up for them to use children, and the risk of them using synthetic data or creating synthetic child pornography, their risk would go down. So they're less likely to use actual children. So there's an incentive there. And we could easily catch those who are truly out there abusing children, and less children will be trafficked. So it was a thought that is, I put out there to be explored. Is it flawed? Probably. It is relying on game theory, really, that everybody's a rational actor. That is not the case. If you're producing child pornography, you're not a rational actor. But it is something that I think is worth thinking about, and forcing legislators to step back and say, yes, there is an urgency to put in legislation, but we need to step back and have a real discussion on, instead of putting a Band-Aid on a wound, how can we properly, like, surgically fix this issue so it doesn't get to a point that it proverbially needs to be amputated? Because then we're just throwing Band-Aids on Band-Aids on Band-Aids, and we're having a First Amendment issue. We're having issues where data privacy or invasion of privacy is taking place. So I'm really interested on what your thoughts are for that.
If I could jump in, Professor Virati, you said something, Ms. Ganesh, and I just realized suddenly, oh, I read her article. I read it just 2 days ago on a plane, and I went and pulled it up, and I remember very well your conversation about this, and I'm sorry that I didn't make the connection before now, but
well, I'm glad you read it. Somebody read it.
You betcha. And made comments in the footnotes or in the margins. I think that to couple of your questions, that as far as at least the Ferber court thought that taking what the state of New York said, that its argument was for penalizing not only the making but the distribution and then ultimately the possession of child pornography, is because it isn't primarily to prevent harm to future children, although that was part of it, but it was the harm to the children who had actually already been abused. And so to that point, I think that you make a strong point for the question of whether or not AI, and I appreciate the distinction between using child pornography and CSAM, Ms. Amlani, so thank you very much for that. I think that the problem with reaching conclusions at this point is that we don't have the science, or at least enough evidence that would be enough for any court to decide whether or not we have a compelling interest that needs to be served here, and whether or not just as there's plenty of science that says that the use of violent video games leads to a normalization of violence, and then perhaps the predilection to engage in violent activities. That's something that the court was looking for, something much more solid than what we have today. If you've got evidence on both sides of the issue, then
it's almost neutral. It cancels each other out. And I think there's a huge hesitation for the scientific community, like for psychiatrists, to jump headfirst into something like this, because one, it's kind of icky. Two, it's hard to get funding for it. And three, it's one of those things which I like to say, if you're going to understand how hell works, you need to get comfortable talking to demons. And that is something that I think we all need to get comfortable with when we talk about a solution to protect the vulnerable, is we need to figure out that brain. How does it work?
I'm curious if our other panelists have thoughts on this. If we acknowledge at least the argument that there may be a harm reduction effect to synthetic depictions, whether those are digital or oil paintings or anything else, does that suggest that our enforcement priorities as to existing laws should focus should be focusing perhaps in relationship to the amount of humanity that was involved in their creation, or is that too much of a sliding scale? Should we just be seeking a different approach?
I can kind of kick that one off. I think this is, in general, a very gray area because we're touching on free speech. We're touching on internet. We're touching on technology. This technology rapidly improves every day. This conversation we have right now could wind up being obsolete next year at the exact same time or in 6 months. But I think what we need to start having law enforcement do is I think we need to, one, have massive improvements in training for law enforcement. I think we need to have more education and research around the use and distribution of child pornography. And I think we need to have legislation that can help hold technology companies more accountable in the sense for recourse for victims who have been previously victimized. And I remember in February or end of January, there was talk of Section 230 of the Communications Decency Act. There was talk about rolling back some of the protections of liability for tech companies that got quite a bit of bipartisan support, with a lot of other child CSAM, bills on how to hold, how to protect children from CSAM. And I think the biggest concern there, and I think it's a valid concern, is can these rollbacks cause companies to have a knee-jerk reaction in more monitoring in their data, almost over monitoring, and causing them to start going into everybody's personal data, and communications will be a lot less secure. And if that's being done by a government that is maybe not so friendly to minorities, I won't say it out loud, but Kamala Harris's opposition, this could mean real harms to LGBTQ communities and children, and it could cause the opposite effect of putting more children in danger and more susceptible to other forms of sexploitation, I think. So in terms of like criminal law, I think it's going to take a lot more parsing out of one of the main statutes federally used, because in child pornography, whenever the internet is used, it 9 out of 10 times will fall under federal jurisdiction. I think we need to start parsing out 18 U.S.C. 2251 to 2258 a little bit more, and we need to revise it to have not include in one statute possession, distribution, and creation. We need to separate it into subpart A, possession, subpart B, possession and distribution, and have different consequences and different criminal methods of handling those two categories. Because again, possession and distribution creation are two very different things and have two different meanings that we need to further explore.
One thing to add.
Yeah, please.
And I'll just start, but if you have a specific question, let me know. But I think one of the challenges with an increase in legislation is what you said, Ms. Ganesh, is that there is the potential for over removal and an over restriction of content on a service. So if you increase the penalties for a company allowing the content to even exist on the platform without it even detecting the content, you have to think about what is a company going to do to try to protect itself from that. And that could be allowing less content on the service, or the breadth of the content, or finding ways to sort of automatically remove that in which does not leave room for a nuanced approach to sort of protecting the scope of content that's on a platform. And then I think in terms of requiring companies to do more, I think we're seeing this more in other countries that are not bound by US law. The biggest challenge there is the First Amendment. And there are a lot of laws that are trying to require companies to focus on more affirmative obligations and safety obligations. We're seeing a bit of that now. So in California, there's a new law, AB 1394, that would have a sort of like a notice and takedown regime that's similar to what we see in other countries. But laws that are being passed that are requiring companies to take more action are being challenged. So, and either preliminarily enjoined or struck down. So as an example, there's a law, Texas HB 18, the Scope Act, that would require companies to have basically like a content moderation program, including scanning for content that could lead to child sexual abuse material, child sexual exploitation, etc. And that law is preliminarily enjoined because it's been challenged by a few different groups based on the First Amendment protection. So the US handles these issues a bit differently, but it's something that we are seeing a lot of. So like you said, Ms. Ganesh, proposals to limit CDA immunity, and then in general, state and federal proposals to address providers' obligations in connection with online child sexual exploitation.
Yeah, and I'll just talk a little bit about something I keep thinking about in this conversation is, just because we have these technologies, especially, I'm thinking about like AI technologies, ChatGPT, Midjourney, et cetera. And, they're a little bit different than, platforms to some degree because like you're able to produce the content therein. And, the scale with which these generative AI technologies have, really exploded in the last couple of years without any guardrails, I think is something to pay attention to as well. There are, I think that there are some palpable, pressing arguments for these technology companies to slow down and, really think about what they're enabling and what they enable people to do. And, it needs to necessarily be a nuanced, long-term, slow decision-making process that can, incorporate scientific, research, like you were talking about, Ms. Ganesh, that just doesn't exist yet, right? And so, I know that people argue that this argument sort of stifles technology creation, production, and deployment. But at the same time, I think it's an open question. Like, is this the type of technology we want that, moves forward at breakneck pace, simply to make profit for shareholders without any regard for the public that it's being deployed into? And so, I think that that's always where I come back to in these arguments, right? Like, there are many stakeholders, if you want to call them that, within this argument. And technology companies are often not really, addressed within these because, they're protected by Section 230 and, we don't want to stifle innovation and technology. Companies in Silicon Valley is very powerful, but, I sort of keep coming back to this in all of these discussions is like, if companies can't meaningfully and, sort of thoughtfully moderate content at the scale with which they exist, should they exist at that scale? And if so, like, how might we rein in some of this activity?
I like that you mentioned, basically something that I keep coming back to, which is, from a policy perspective, what are we trying to do here? Who are we trying to protect? What are our goals? And I think that that has those answering those questions has to be part of any deliberative process and figuring out how to deal with this. I do, are we looking, for example, to try to prevent child pornography or those images becoming more of a normal within the framework of what we would consider, well, this is just a type of pornography by its sheer prevalence on the internet, that, so then I think that we would have a different reason for a different doctrinal approach to regulating it. But lastly, I do wonder if with the First Amendment being such an obstacle, perhaps countries like or organizations like communities like the EU, if you have laws that would regulate any number of tech companies that do business both in the United States and everywhere else in the world, they will be influenced by and have to react to the laws where they still want to conduct business. So perhaps that's where we have a bit of a saving grace, and I think we see that also in most recently in the way that internet sites have started to ask us our permission for dropping certain cookies onto our computer, right? Like that wasn't necessarily come from a United States pressure, but rather overseas. I know we're running out of time, but thanks for that.
Indeed, thank you. I want to acknowledge really my own abject terror of being automatically shut off at 2 o'clock, and just want to take a second to really express my personal deep thanks to each of you. Harshita Ganesh, Pamela Vesland, Britt Paris, and Natasha Amlani. I will personally be reaching out quite a bit more. I have so many more questions, particularly one that was raised by this panel is the interrelationships between private enterprise and government and finding the line. Some of you may have seen the news yesterday that ChatGPT was going to be transitioning away from a nonprofit structure, and there are other phenomena to chat about. So hopefully this is the start of a conversation, and these questions we've raised today will continue to learn about the answers and seek for the answers together. But really with that, thank you all so much for your time. We really do appreciate you.
Thank you so much for having me.
Thank you.
Thanks.
I enjoyed it.
If anyone
Thank
has
you.
questions, feel free to email us.
Yeah.
Yeah,
Or if
we will,
any new almost done law students have any questions and want a panic vent about the bar coming up, feel free to shoot me an email and I can alleviate those stresses. Just finished that. So
Beautiful. Thank you so much. We will circulate that contact info for those who are comfortable sharing it. Thanks again to Linda Gudemon. Thanks again to our incredible AV team who have made us look and sound much better than we deserve. And we will see you all at the next symposium event. Thank you very much.
Thank you.
bye.
Bye.